Members of the jury, the question has been asked whether the jurors may take notes. The answer is yes, you may take notes if you want to. Whether you take notes or not, you should be aware that the court reporter records everything stated in the courtroom, and any portion of the transcript, at your request, will be read back to you during your deliberations. If you do take notes during the trial, you should not allow your note-taking to become a distraction from the proceedings. If any of you do take notes during the trial, those notes are only for your personal use and are simply an aid to your memory. Because the notes may be inaccurate or incomplete, they may not be given any greater weight than your independent recollection. Because the notes may be inaccurate or incomplete, they may not be given any greater weight or influence than the recollection of other jurors about the facts or the conclusions to be drawn from the facts in determining the outcome of this case. Those of you who do not take notes should rely on your independent recollection of the evidence and not be influenced by the fact that another juror has taken notes. Any difference between a juror's recollection and a juror's notes should always be settled by asking to have the court reporter's transcript on that point read back to you. The court transcript should govern your determination rather than a juror's notes. A juror's notes are not a substitute for the official record or determination rather than a juror's notes are not a substitute for the official record or for the governing principles of law that I will give to you. Whether to allow jurors to take notes during the trial rests in the sole discretion of the trial judge. The Court of Appeals has held that a trial court, although not obligated to do so, has the discretion to permit note-taking by jurors during a trial. People versus Hughes, supra, if a trial court determines that a particular case warrants note-taking, the court can, sua sponte, instruct jurors that they are permitted to take notes during the trial. In light of the potential perils that note-taking can present during trial, preliminary cautionary instructions should be given with respect to note-taking and these notes. The instructions should also be repeated at the conclusion of the case as part of the court's charge prior to the commencement of jury deliberations. People versus Hughes, supra. People versus DeLuca, supra. The pattern charge is meant to be used when the issue arises during the course of the trial. If the jury has taken notes during the trial, the second paragraph of the pattern charge may be adopted or adapted for incorporation into the charge at the end of the trial. If the court allows note-taking during its charge, the court should instruct the jury that any disagreement among them about the law or evidence, especially between a juror's recollection and another's notes, requires a readback of the charge. Jurors may take notes during supplemental charges if cautionary instructions are given. People versus Tucker, supra. However, it is error for jurors to take notes on the judge's oral charge if no cautionary instructions are given, or if the cautionary instruction failed to remind the jury that notes were only for the note-taker's personal use, and that jurors had to request re-instruction if there was any disagreement. It is also error to permit jurors to take notes when the requested portions of testimony are read back during deliberations where no cautionary instructions are given. People versus Stewart. For the appropriate procedure regarding note-taking by jurors, see the following. If any of you has a question to ask a witness or the court, please write the question on a paper and the court officer will deliver the question to me. For legal reasons, I must decide whether and how the question may be asked and what procedure to follow. Caveat: this charge should only be given if a juror seeks to ask a question. To what extent, under the circumstances peculiar to this trial, of each cause questions should be permitted by jurors is a matter that should be left to the discretion of the trial judge. If the trial judge decides to allow jurors to propound questions, the best practice is to have the jurors write out the question and to have the court or counsel ask if the witness, subject to applicable evidentiary rules, wishes to ask it. People versus Wild. Federal annotation. The federal rules of evidence are silent on the question of jurors interrogating witnesses. However, federal courts conclude that allowing jurors to question witnesses is within the discretion of the trial judge. When allowing juror questioning of witnesses, it is preferable that the court require jurors to submit questions in writing and without disclosing the questions to other jurors. United States versus Polowich, 783 F. 2nd, 410, 4th Circuit. Is it? 180.
It's tough.